She told the room I was about to get nothing, and for a full breath everyone believed her. By the time the notary broke the red wax and slid the will across the oak table, my aunt was already smiling into her victory. She didn't know the page I carried would turn that smile inside out. If you clicked because the title said, "This is the will reading," where a relative tried to take a $450,000 inheritance, and I flipped it, you're in the right place. This is exactly that story. It's not fantasy, and it didn't play out neatly in an hour. It took weeks, dates, documents, and a few quiet choices that looked like nothing until they were everything. My name is Lauren Pierce. I'm 36, American, and I run a YouTube channel called After Her Lies. I tell stories about family, money, and clawing back justice without losing your soul. This one is about my mother's sister, Heather, the Dayton bank where we sat under buzzing lights, and the paper she waved like a flag. It's about a will dated March 14, 2021, a power of attorney executed on September 2, 2020, a transfer on death deed filed April 6, 2022, and a number that made everyone act strange, $450,000. That was the value of my mother's estate on the inventory filed in probate, counting the house on Cromer Road and the proceeds from selling Pierce Heating Air, the small business my dad built over 17 years before he passed in 2018. It's money you can hold in your hands, but also money that can make people forget who they are. I grew up in Dayton, Ohio. My mother, Elaine, taught 3rd grade. She was steady and fair. When she got sick in late 2020, first a knee replacement, then a pneumonia that slid into something harder, Heather moved in to help. And for a while she did. She took Mom to appointments, kept the pill caddy, stayed the night when oxygen levels wobbled. I was there on weekends and some evenings, but I live in Cincinnati, an hour down I-75, with a job managing content for a non-profit, and my channel running on late nights and coffee. My older brother Mark is an electrician in Kettering, pulled between overtime shifts and 2 kids. Heather was charming in the ways that count at hospitals and church. She knew how to bake a casserole that made you cry, and how to ask a nurse for one more blanket without sounding demanding. She had a flair for paperwork and a knack for telling a story where she was always the one who saved the day. When Mum's will was first drafted in 2017, it was simple. Everything split between Mark and me, with a $25,000 bequest to Heather for gratitude and care, and a line about my dad's business if he died first, which he did in November 2018. After Dad died, the business was sold in 2022 for $310,000 net, and the proceeds were put into a brokerage account in Mom's name ending in 6283. There was a trust contemplated in the will, but no separate trust document. It was a testamentary trust, only to spring if I was still under 25, which I wasn't. On paper, it was all straightforward. But paper can be a stage for someone else's story if you're not watching. In September 2020, when Mum was recovering and anxious, Heather drove her to an attorney, not my mum's estate lawyer, but a different one, and had her sign a durable power of attorney. That's not illegal. People do it. But it matters what the document says, and when it can be used, and who's holding it. By Thanksgiving 2024, Mum was weaker. She had heart failure with a brittle rhythm that made her tired just brushing her hair. At dinner, after grace, Heather tapped her glass and said, like she was announcing a graduation, "Elaine has updated her arrangements, everyone. It makes the most sense. I'll be handling everything. There won't be confusion or arguments." She said it sweet, like she was sparing us, but her eyes never came to me. "And I'm executor," she added, loud enough for the cousins at the kids' table to go quiet. It was a public moment, a little humiliating, the way everyone looked down as if the turkey needed inspecting. Later in the kitchen, over dishwasher steam, I asked her to show me the document. She laughed. "It's handled, Lauren. Don't worry your head." Mum died on February 14th, 2025. It was 7:18 a.m., and the nurse called me when the monitor traced a final flat line, and for a few hours none of this mattered. We were just daughters and a son. I held Mum's hand and watched the lines in her palm like roads no one could drive anymore. Then the practical work began, because death asks for signatures and inventory sheets even when you haven't slept. We met at the bank on March 3rd, 2025, for the will reading because Heather said she preferred a professional environment, and because the bank's trust officer, a man named Strauss with a deliberate handshake, had a conference room with a door that closed. The notary, a woman with square glasses and calm hands, sat at the far end with a leather-bound notary journal. The envelope lay in the middle. Mark was on my right, checking the time because he had a service call at 2 p.m. Heather sat opposite, a stack of folders at her elbow like trophies. On top was a manila folder labelled Todi Deed, House, and beneath it a printout of an account statement with the number 6283 visible through a clear sleeve. "Let's be efficient," Heather began. "Elaine executed a codicil to the will in 2023 and also transferred the house to me through a transfer on death deed. We don't need to drag this through probate. The brokerage is payable on death to me, and per the codicil, I am the sole beneficiary, with the understanding that I'll take care of everyone's needs." Elaine wanted to keep things easy. I felt the room tilt. Heather looked not at the notary, not at the trust officer, not at me. She looked at the wall clock like she was counting down to applause. It was, if I'm honest, a tight, careful performance. It worked. For a moment, Mark blinked like he believed he'd awakened into a different life, a simpler one, where the numbers vanished on a puff of understanding. "Before anything else," I said, keeping my voice low because that's how you keep the room from falling apart, "can we read the will?" Strauss cleared his throat. The notary broke the seal. The pages whispered as we shifted them, and I saw Mum's signature loop in blue in the same way she'd signed our permission slips in 3rd grade. The will was as I remembered. 2017, witnesses, the $25,000 to Heather, the remainder to Mark and me in equal shares. There was no codicil attached. The notary's journal had no entry for a codicil in 2023, at least not in front of me. Heather tapped the manila folder again, not looking at the will. "That's outdated," Heather said, almost bored. "Elaine later appointed me attorney-in-fact and named me beneficiary on the account. Talk to any bank, that controls." "What's the date on your power of attorney?" I asked, because I already knew, and I wanted her to say it where someone wrote things down. "And does it spring on incapacity or is it effective immediately?" Heather smiled in a way that had nothing to do with me. "September 2nd, 2020, effective immediately. I needed to help her." "Do you have the original?" I asked. "I have a copy. The bank has the original." The notary folded her hands. "We're here to record the will," she said gently. "Are we also discussing non-probate transfers?" "We are," I said, "because they don't exist. That's not how you make friends. But justice doesn't need charm early. It needs a spine and a timeline. The pressure was real and public. Heather had been Mum's caregiver, and there's a halo people put on caregivers that makes them hear them first. She had the keys to the house, the alarm code, the pill organizer. She had friends at church and a gentle voice. When I went to the bank the week after Mum died to ask about the brokerage account ending in 6283, the teller looked at me with soft eyes and said it was under review due to a beneficiary designation change in 2023, and that privacy laws limited what they could say. I counted 3 obstacles in one sentence: the bank's policy, Heather's preemptive story, and the fact that grief makes everything heavier. I didn't start with accusations. I started with paper. I asked Strauss for a simple thing: a copy of any power of attorney and any beneficiary change forms in the bank's possession, and the notary journal entries for any will-related documents. He told me to make the request in writing. I wrote it. I sent it certified. I took notes with dates and times. March 5th, 2025, request sent. March 9th, acknowledgement received. I went to the county recorder's website and typed my mother's name. The transfer on death deed popped up. Filed April 6, 2022, signed by my mother, notarized by someone whose stamp I didn't recognize, naming Heather as beneficiary of the house. The legal description was correct, the parcel number was listed, the recording fee paid. It wasn't sloppy. It looked real. But documents tell their own secrets if you read the footnotes. The TOD deed was on a standard Ohio transfer on death instrument, and in the corner, Revum 6 2021. The notary stamp was from a county 2 hours away. That alone isn't suspicious. People move, but it meant questions. The deed had a line for the grantor's acknowledgement. It also had a line for the notary's journal entry reference number. That number didn't match the sequence of rest of the notary's monthly entries when I later pulled her public log. It skipped. People who forge things don't always misspell words, but they often misjudge sequences. I requested Mom's medical records for April 6, 2022. The hospital said she'd had an outpatient procedure that day, a moderate sedation for a cardioversion. If the deed was signed that day, it raises a capacity question. Capacity is not about IQ or love. It's about whether a person knows what they are doing at that moment when they move a pen. If a person is under midazolam and fentanyl in the morning, can they understand property transfers in the afternoon? Maybe, maybe not. But maybe is a space where truth can breathe. I also asked for the bank's forms. On March 12th, Strauss emailed a PDF, the power of attorney from September 2nd, 2020. It was a springing POA despite Heather's claim. It said in clean, placid legalese that it became effective only upon the written certification by 2 licensed physicians that the principal, my mother, lacked capacity to manage her property. 2 doctors, not 1, not a nurse, not a daughter's opinion. There was no attached certification. There was also a clause about gifting. The agent could not make gifts to herself over the annual federal exclusion amount without express language, which the form did not contain. That line was small and likely invisible to most people because life is busy and forms are boring. But it brightened on the page as if the ink got oxygen. You can't accuse someone of elder financial abuse without a slate of facts and a stone heart. I didn't want to be a person who swung a word like abuse like a bat. Heather had been kind in real ways. But when I lined up the dates, the POA that needed 2 doctor letters, the TOD deed on the day of sedation, the alleged codicil no one could produce, the storyboard wasn't a Hallmark movie. It was a timeline with pressure points. I called Mom's old estate attorney, Mr. Barron, who still records everything on legal pads like it's 1998. He had no record of any codicil. If she'd changed it, he said, she would have done it with me. We talked around Christmas 2023 about final wishes. She reaffirmed the 2017 plan. He sounded tired through the phone, like this scene had played in his office a dozen times for other families. I went to the notary who signed the TOD deed. Her name was printed on the stamp, and notaries are public officers. I asked to see her journal for April 6, 2022. Ohio doesn't require notary journals, but many keep them. She did. The entry for my mother was there, time 3:18 p.m., with a driver's license number recorded and a signature. The entry before it was at 5:40 p.m. It skipped. Numbers don't lie. They also don't explain themselves. Do you remember her? I asked. The notary squinted. I notarize a lot, she said. A woman in a blue cardigan, maybe. The building was a UPS store. I walked back to my car with that tiny sentence in my pocket, which felt like a pebble and not a stone. Mark wanted it to be easy. If Mum gave Heather the house, maybe that's what she wanted, he said. His voice had been sanded down by years of hard work. He didn't say it cruelly. He said it like someone who could accept a loss if it meant no fight. It's not about the house, I said. It's about the way. I also had something else Heather didn't know about because she didn't know me as well as she thought. My channel and my non-profit job have taught me to document. I had, in a folder on my laptop, a recording of a conversation in my mother's kitchen on April 8, 2022, 2 days after the TOD deed was filed, made, because Mom asked me to set my phone on the table to capture her instructions for her funeral playlist, hymns and a halting verse of How Great Thou Art. The recording was legal. Ohio is a one-party consent state. During that recording, while the phone faced up under a paper towel like a shy turtle, Heather walked in and said, clear as bell. Good, we got that signature done. Now there's no way Lauren can tie up the house in probate. I can just file the affidavit when the time comes. Mom murmured something about always being fair. There was clinking. A cabinet closed. You'll be taken care of, Heather said. You don't want a fight? I hadn't thought about that recording for 2 years. Grief makes you forget even your own habits. But when I listened to it again after Strauss sent the POA, it clicked into place like a seatbelt. It didn't prove incapacity. It did prove intention, that the transfer was engineered to avoid probate and to disinherit me and Mark, contrary to the 2017 will. Intention matters when you're arguing undue influence. So do relationships and timing. So does who drove the car to the UPS store. I called a lawyer. Her name was Rachel Finley. She is 5 feet tall and scarecrow tough. We met in a little Italy coffee shop in Cincinnati because her office is noisy, and so was my head. I slid across a binder with tabs, medical records, bank forms, notary journal, the will, the POA, and a typed timeline. I showed the recording. She listened, looking not at me but at a point in the distance, as if she could see the case sketched on a whiteboard I couldn't. You're not wrong, she said after 10 minutes. You're also not ready. We need an affidavit from a physician about capacity on April 6, 2022, or at least something that casts doubt. We need to challenge the TOD deed for undue influence and lack of capacity. We need to file an application to admit the will and object to any non-probate transfers that were procured by an agent under a power of attorney that wasn't properly sprung. And we need to move fast before anyone drains anything. How fast? Today. We filed in Montgomery County Probate Court on March 18, 2025. The case number was 2025 ES 0387. Rachel handwrote the caption because the e-filing portal hiccuped and because sometimes a pen is faster than a server. The filings included a caveat to the probate of any later instruments purporting to be a codicil, a motion to freeze account number saying scene 283, pending determination of the validity of any beneficiary designations changed by an agent, and a petition to set aside transfer on death deed due to undue influence and lack of capacity under RC 5302, 22 and 213109. We attached Mum's 2017 will as Exhibit A, the POA as Exhibit B, the hospital record showing sedation as Exhibit C, and my transcript of the kitchen recording as Exhibit D. We asked for a temporary restraining order preventing the bank from honouring any payable on death designations pending a hearing. We drew Judge Carraway, who has the eyes of a person who reads fine print for leisure. She set a hearing for March 27th. That gave us 9 days to build a bridge over a river we couldn't see the bottom of. I called Nurse Delgado, who had taken Mum's vitals before the cardioversion on April 6, 2022. Her name was on the chart. I asked if she remembered my mother. She was small, the nurse said. Worried, very polite. Did she remember the sedation? Standard protocol. She needed a ride home. No driving, no legal decisions. We tell them that. It's in the discharge instructions. Could she sign an affidavit? I can write a statement that we gave the instruction. I can't opine on legal capacity. It was enough. We didn't need an opinion. We needed a stone in a jar. Heather wasn't idle. She filed a response calling me estranged and mercenary, accusing me of weaponizing grief. She attached a picture of her and Mom planting lilies in 2021, both smiling. She had also restrained the tone to sound reasonable. Elaine wanted to avoid probate. She trusted me. Lauren is overreaching. That sentence lands in a courtroom like warm honey. People want to believe love translates into paper. Sometimes it does. Often it's turned into a lever. I got a text from a cousin I love, 1 line long. Please just let it go. It was public in its way because texts are tiny billboards of what people are too tired to say out loud. I put my phone face down and kept going. Growing up, my dad used to call me Blue Book because I'd write every car's maintenance history in a notebook and tape a receipt to every page. It was annoying then. It saved us now. On a whim that felt like a waste of time until it wasn't, I went through Mum's old emails. There, on March 13th, 2021, the day before she signed the will, was an email from Mr. Barron's assistant with a PDF titled Final Will, Elaine Pierce. In the body, a line that made me sit so still the room went thin. Per your request, we added a clause limiting the agent's power to designate beneficiaries on your accounts. Any changes to death beneficiaries by an agent are void unless specifically authorized. It wasn't in the will itself because that governs probate property, but the assistant referenced a memo Barron had provided to Mom to take to her bank, suggesting she lodge it. I checked Mum's file folder. The memo was there, creased and coffee-stained. The memo was addressed to the bank. It said in clear words that Elaine does not authorize any agent to change beneficiary designations on her financial accounts. It wasn't a statute, it wasn't iron, but it was a rope we could pull. I felt something hard and old click in my spine. We revised our motion to include the memo as Exhibit E, along with an email header showing it had been sent on March 13th, 2021. Heather's narrative of a sweeping authority shrank a little in the corner. The night before the hearing, I slept on my couch because my bed felt like too much expectation. I woke at 4:12 a.m., drank hotel room coffee in my own kitchen, and read our binder again. At page 132, in the middle of the bank's POA form, right after the gifting clause and before the severability section, was a sentence I had skimmed a dozen times, but never truly saw. This power shall not be used to create, change, or revoke a beneficiary designation on any account unless expressly permitted in Section 12 herein. Section 12 was blank. I stared at the emptiness like it was a word. It wasn't a word. It was the absence of permission. It was the silence that became a wall if you pointed to it hard enough. And then I saw the clause nobody expected. Probate court on March 27th looked like a classroom for adults who finally cared about the rules. The flag by the bench, the recorder with her fingers ready, the pews worn smooth. Heather wore a navy suit and a pin shaped like a dove. She didn't look at me. Rachel's blazer was threadbare at the cuffs, which I loved her for. The bank had a lawyer too, stiff and careful because banks don't like surprises. Judge Carraway didn't smile. "We're here on a motion for a temporary restraining order and a petition to set aside a transfer on death designation," she said. She summarized our filings better than I could have. She asked for evidence. Rachel stood. "Your Honor, we have 5 points," she began. 1, the will is valid and has no codicil on file. 2, the power of attorney is springing and lacks the required 2-physician certification. It authorizes no self-dealing gifts over the annual exclusion. 3, the bank's own POA form prohibits an agent from changing beneficiary designations absent express permission. Section 12 is blank. 4, the transfer on death deed was executed on the day of moderate sedation, and the hospital discharge instructions caution against legal decisions for 24 hours, as attested by Nurse Delgado. 5, we have a recording dated April 8, 2022, indicating an intent to circumvent probate and existing testamentary intent. She played 30 seconds of the kitchen recording. The room heard Heather's voice. It wasn't open mic sharp. It was domestic, ordinary, and impossible to mishear. It hung in the courtroom air like a draft. Heather's attorney, a man with a too-light tie, objected to the recording as sneaky and taken without knowledge. The judge asked, "Ohio is one-party consent?" Rachel nodded. "Overruled," the judge said. Heather's attorney argued capacity. "Adults have the right to arrange their affairs, Judge. A transfer on death deed is easy precisely so we don't jam your docket with funerals. The notary journal shows a signature. My client provided care for years. She deserves certainty." "Desert is not the standard," Judge Carraway said. "We apply statutes to facts." The bank's lawyer cleared his throat. "We're here primarily to abide by court orders," he said. "But to be clear, our form does prohibit agents from changing beneficiary designations unless the principal specifically authorizes it. We have no record of such authorization in Section 12. If the agent presented a beneficiary change, the bank would need to review whether that was valid under our policy. For now, the funds are frozen pending this court's direction." Heather turned to him then, surprised, because she had thought the bank stood in the dark corner and would stay quiet. It didn't. Institutions talk when you bring them their own words. Rachel called me. I told the story the way I'm telling you now, but with fewer adjectives. "I loved my mum," I said. "She used to underline in library books very lightly so she could erase later. She believed in fair. The will is her words. We didn't have a single knockout punch. We had 5 respectable jabs. That's how most victories look up close. A series of boring, correctly made points said calmly until they shift the room's center. The judge took 10 minutes. 10 minutes can feel like a year if you can hear your own breath. When she returned, her ruling was clean. On the record evidence, the court finds a substantial likelihood that the power of attorney at issue required 2 physicians' certifications of incapacity, which are presently absent from the record. The court further finds that the bank's power of attorney form furnished to the principal prohibits the agent from altering beneficiary designations, absent express authorization, which is not present in Section 12. The court notes the existence of a recording indicative of intent to circumvent the will and the timing of the transfer on death deed, contemporaneous with moderate sedation. The temporary restraining order is granted. The bank is ordered to maintain the status quo regarding account 6283 pending final hearing. The transfer on death deed is suspended pending evidentiary hearing. No affidavit of death shall be accepted for transfer. Letters of authority shall issue to the executor nominated in the 2017 will upon application. She looked up. Who is the nominated executor? Me, I said, my voice smaller than before. File your application, Miss Pierce, she said. We will set a full hearing on the deed within 30 days. Heather's face did a strange thing then. It smoothed like someone had ironed it, then creased in the middle as if a stitch had failed. She wasn't a villain in a movie. She was a woman who had made choices on a slope and now found a floor under her feet that she didn't like. People think the gavel falls and everything is over. It isn't. There was still a month, more filings, subpoenas. We got the physician certifications for April 2025. Too late to spring the POA for 2022 acts. We took depositions. The notary admitted she didn't check the sedation status because notaries aren't doctors and no one expects them to be. The hospital produced the discharge instruction with Mum's squiggly signature and a box checked. No legal decisions for 24 hours. Mark took a day off work to sit in the hallway and listen through the door like a kid, and I loved him more for showing up than for what he believed. The full hearing was on April 25th, 2025. We brought a hematite bowl of facts and set each one down without throwing any. The judge found the TOD deed void due to undue influence and lack of capacity. She didn't use the word fraud. She didn't need to. She used equity and constructive trust. Those words hold power because they're about fairness when the law is too narrow. She ordered the house remain in the estate. She ordered an accounting by Heather for any transactions conducted after September 2nd, 2020 under the POA. She ordered the brokerage to pay into the estate for distribution under the will. Numbers are lava until they cool into orders. When they did, here's what it meant in concrete terms. The $450,000 estate would be distributed per the 2017 will, half to Mark, half to me, after paying debts, taxes and costs. Heather would receive her $25,000 bequest, but the court also indicated she might be surcharged for any unauthorized transfers, a word that sounds like electricity because it is. The court appointed me executor on May 1st, 2025. I filed the inventory on May 20th. I filed the accountings on June 30th. I paid the last utility bill and cancelled Mum's streaming services, which made me cry unexpectedly because even grief has a password. People asked if I wanted to humiliate Heather. I didn't. I wanted a record and a boundary. Consequences came in their own shape. The court's surcharge order, issued July 15th, required Heather to reimburse $17,400 in cash withdrawals in 2023 that she had labelled gifts to caregiver beyond the annual exclusion. It also voided a $12,000 cashier's cheque to her son labelled tuition that came from Mum's account because the POA didn't allow self-dealing. Those numbers aren't cinematic. They're real. They changed the math of someone's summer. She paid under protest. The house stayed in the estate. We sold it for $220,000 on August 8, 2025. I signed the closing statement at 11:42 a.m. and drove to Cromer Road one last time to pick up a terracotta pot my mother loved and a bag of faded recipe cards. Heather and I haven't spoken since the day of the April hearing. She sent a 2-line email in May offering to buy the house at a discount to avoid realtor fees. I declined. She lives across town in a rental with a front porch and a chain of wind chimes that never stop, and I hope she's okay. I don't say that to score points. She cared for Mum in ways I will always see when I close my eyes. She also made choices under the roof of that care that turned the air heavy. Family isn't a judge's problem, it's ours. We're living with it. Mark took his share and paid off his truck loan and put $50,000 in a 529 for his daughter, born March 2nd, 2022, who is 3 and calls me Lolo. I put mine into a trust with a practical name, opened a separate account for taxes, and then bought myself a kettle that heats to exactly 205 degrees, because small luxuries are the safe kind after a big storm. I gave $5,000 to the non-profit where I work because even justice looks better when it circulates. The channel, after her lies, grew during this. I didn't film in court. I didn't make anyone a villain. I did something else. I turned on the camera the night of March 27th and told a calmer version of how we got the temporary order. I held up the POA and read the sentence about beneficiary changes, and people flooded the comments with their own lines that saved them. It wasn't viral in the way balloon pranks are viral. It was steady, like a tide. It felt like what I always wanted the channel to be, a way to leave the door cracked for someone else who is sitting in their car with a shaking hand and a binder full of tabs, wondering if they're crazy for pushing. There's a detail I haven't told you because it's small and big at once. On the day of the first hearing, as we left the courthouse, a woman I didn't know stopped me on the steps. She wore a cardigan too thin for March and held a folder to her chest like a baby. "Are you Lauren?" she asked. I nodded. "I watch your channel," she said. "I'm going through something like this with my brother." She swallowed. "Your voice helps me not yell." I thought about that a long time. There are different kinds of winning. Some feel like trophies, some feel like not yelling. My mother's funeral was simple, March 1st, 2025, at St. Luke's, with lilies and plain sandwiches in the fellowship hall. Heather sat in the 3rd row, angled away. The pastor talked about the Beatitudes, the ones about meekness and mercy. I know they're not instructions for passivity. They're instructions for how to move through a world that will ask you to be meaner than you want. If you're listening for the twist that made everyone gasp, it's quieter than that. The twist was a clause in a bank form that most people ignore. The twist was a nurse's checkbox. The twist was the judgment of a court willing to say that convenience isn't a synonym for consent. The twist was that you can be timid and still bring the room to order if you bring the right paper. Months later, I walked through the now empty house on Cromer Road with the realtor behind me. The nursery my brother and I shared had a faded crayon line still on the wall. I touched it and said, "Mum always left a light on." The realtor didn't know what I was talking about, and that's okay. "Not everything is for the listing," Heather's friends whisper. "Family matriarchs nurse grudges like tea. None of that is mine to control. What I can tell you is what changed for me. I sleep more easily, I answer email faster, I label things, I bake from my mother's cards, and half the time they taste like paper, and half the time they taste like 1992. I keep the binder on a shelf, not because I want to relive it, but because sometimes someone writes me and asks, "How do I start?" And I can take a photo of a tab and send it, and it's a map. If you're carrying something like this, here's my advice that isn't advice. Line up the dates, ask for the forms. Don't be dazzled by anyone's certainty, including your own. Speak in sentences that can be transcribed. The people across the table are human too, and they might surprise you by obeying their own rules if you show them where they wrote them. And when the envelope is opened and someone smiles because they think the story is over, remember, it might just be the middle. Somewhere there is a sentence you've read a dozen times that will change everything if you let it. It waits for the morning your eyes are less tired. It will look like nothing. A blank section 12, a memo sent on a Saturday, a discharge instruction with a check mark, It will be the clause nobody expected, and it will carry you to a different end than the one someone rehearsed. I'm Lauren, and this was After Her Lies. If you made it here, you're the kind of person who reads to the footnotes. I like you for that. 96% of viewers aren't subscribed, so if this helped you, please subscribe, like, and comment.